All right, good morning, everyone. My name is Justin Taylor, known as the Education Link. And today we have attorney Jessica Patterson out to teach us about wills and estate planning. Here at RealLink, we try to highlight people that are out doing the work on the ground level, and we're all about acquisition and retention when it comes to home ownership. You go ahead.
All right, well, hi everyone. Thank you for having me. Again, my name is Jessica Patterson. I am very happy to be here. Anytime I can talk estate planning to, let's face it, our community, it feels like I'm talking to friends and family, so that's always a good feeling. All right. So welcome again. I'm Jessica Patterson. A little about me. I'm the managing attorney at the JRP Law Firm right here in Houston, where we specialize in estate planning, probate, school law, guardianship, and small business matters. We pride ourselves in being your lawyer friend. That's kind of our thing, your lawyer friend, because we believe in being more than just lawyers. All right. So today, some of the things I wanted to talk to you guys about is estate planning. We're gonna talk about the importance of estate planning while buying a home. What I realize, especially doing probate, is that a lot of times people wait to start estate planning too late, right? The next thing we wanna talk about is probate avoidance. You know, maybe talk through some ways of why we wanna avoid probate. We'll look at a real world example. And then, of course, we'll make time for questions and answers. And like the true lawyer I am, I have to give the disclaimer that this presentation is not taking the advice of your personal lawyer. So if there are anything unique to your situation, you're always encouraged to talk to a lawyer and don't just rely strictly on this presentation. All right. So in Texas, the top 3 ways that people transfer assets after they die is through a will, otherwise known as a last will and testament, where of course you name someone to be your beneficiary over your assets. You can also do what's called a trust or revocable living trust. Of course, after you pass, the revocability of that trust becomes non-revocable, but it's a way to avoid probate, which we'll talk about later. And then deeds. I know when Justin and I spoke, he wanted to really emphasize the importance of different types of deeds. One deed that's used very commonly is called a transfer on death deed. And that is a way to have your assets automatically transferred to another person once you pass. And the asset, I mean, real estate. All right, looking at the last will and testament. The Texas definition is it's a legal document that lays out your wishes regarding asset distribution after death. Some requirements of a will is it must be in writing, it must be signed by the testator, the person writing the will, and it must be witnessed, or it should be witnessed, by 2 non-benefiting parties. I say the word should because that's highly encouraged. So that way, either you have witnesses witness your will now, or after you pass, you're gonna have to have 2 people come to court and witness your will then, saying that, okay, I recognize that person's handwriting and I can attest that this is their actual will. The benefits of a will is you remain in control of your assets. You get to decide how you want things, and wills are very fluid. So when I write a will for somebody, I tell them, every 4 years, let's look at this. Let's look at your beneficiaries. 1, is your beneficiary still living? 2, do you still have a good relationship with that beneficiary? Because that happens so often. People get divorced, but they name their spouse as the person of their asset and, never change it and so it creates issues later. Courts generally will uphold a valid will. So if the will meets all the requirements, courts aren't going to want to step in and change anything. So your final wishes will be upheld. The downside of a will that some people don't like, or a lot of people actually don't like, is that it must go through the courts to be validated. It has to be publicly probated. So some people, when you have privacy concerns, you don't want people coming out the woodworks trying to see what you had. sometimes a will isn't the most beneficial when it has to go through the probate process. Common thing that people use outside of a will is revocable trust. A trust is, think of it as you're setting up a separate identity other than you as the owner of your assets. So instead of you owning this home, what people would do is they would transfer their ownership to the trust, and now the trust is the owner of the home.
So I'm sorry, did you want all questions at the end? Because I have a question.
Yeah, no, you can. However.
Okay, so about wills.
Okay.
Going back, like I'm 27, I'll be 28 next month.
Mhm.
So I don't have a will, but right now my beneficiary would be like my mom.
Okay.
But how do I say this? Like, how do I determine what's the best way for me to go about with my assets? Because a will is traditional, but I would want to put it in a trust so it is protected more. Sorry, does that make sense what I'm trying to ask?
Yeah.
Like, I don't want to, let's say, give it to my mom and then she just sell it. And because then that, doesn't pass down generational everything. So how do you determine what's more beneficial for you, a trust or a will? Which one?
Okay. So you bring up a couple of the points. First, a will, I always recommend everyone to have a will, regardless if they are going to do a trust later on. Because the thing about a will is when you're estate planning, if you designate beneficiaries on your accounts, like you said, like if you have a checking account with the bank and you put your mom as beneficiary, but later on you write a will and you name your girlfriend as the person that takes everything, the bank isn't just going to give that account money to your girlfriend because you've already designated a beneficiary on those accounts. So what that means is your will becomes second to everything else. So if you have beneficiary designations in place, that's going to trump the will, right? A lot of times what happens though is that people forget to put a beneficiary, or you opened that account when you were 20 and you've just been with them forever. And at the time you may have put your, say your mom as beneficiary, but something happens and your mom passes away before you and the bank doesn't have anyone to give it to. Well, that's why the will that designates somebody else in the event if something happens, that's when that would come into place. But it's not going to circumvent or take over the other beneficiary designations that you already have in place, including a trust. So if there's a trust document that dictates how your assets are to be distributed or held, if you don't want it to be sold, you want it to just be held, then that trust will reign supreme over that will. Okay. So really it just depended on which one is best for you or which one you should prioritize at, young age of 28. It would just really take understanding of what all assets you have now. Do you have designations in place already? And if not, what basically how you see it going in your future, right? And one thing we'll get into with a trust, a lot of people don't do a trust right away because a trust, once you create that separate entity, you're going to have to create those separate entity taxes. So trust comes with taxes that a will won't.
Oh.
So,
Okay.
hi.
Hey, how you doing?
Yeah. Nice to meet you, Jessica. Yeah. So, but great questions. Did you have any other questions about a will? Did anyone have any questions about a will? Yeah.
Mine will probably come.
Okay. No worries.
So I know you passed it because I saw it put on my eye when I started talking to Kim.
Yeah.
You're talking about revocable trust.
We're gonna get into trust after
Yeah, that's
this,
next.
but I was
I had
just
went back.
explaining the different, the most common ways assets are passed. So the first one was a last will and testament, which we just talked about. Then it's revocable living trust, and then some deeds. So those are the most common ways assets are passed in Texas, at least. Okay. So we went over a will, we went over the requirements for a will. We talked about the benefits of the will. like I say, the main benefit of a will is you get to remain in control of the assets. You get to still use it how you want and manipulate it how you want and disregard it however you want. Because the will does not take place until after you pass away, right? But the downside of it, it has to be publicly probated. So if you are concerned with privacy, how much assets you leave in millions and millions of dollars, but you don't want nobody to know about it, sometimes a will isn't the best mechanism for that. Okay. Case in point, I just probated someone's estate, and the day after I put the application in, the person had a will, the day after I put the application in, which we attached the will with it, real estate agents started calling the applicant. The day after, trying to get her mama's home, trying to get her to sell it, trying to be first in line. So things like that happen. I had to tell her, hey, people are going to call you, or they're going to find you, even though your phone number is not listed in the application, but you have to, Texas law requires you to list the last 4 of your driver's license and the last 3 of your driver's license and the last 3 of your social. So with that piece of information, people try to find you, right? So something to keep in mind. That leads us to trust. So trust, like we were saying before, those are legal entities, and they're specifically established for the purpose of holding assets. It's like creating a business that's designed to just hold your stuff, right? Because it's like creating a business, you have to do the things like you would when you create an LLC. You name it, you open separate accounts for it, you get what's called, if you're not going to be the trustee, you have to get it essentially like an EIN number for it, and you have to do what everyone loves to do. We got to pay taxes for it, right? And trust taxes, yes, trust taxes suck, right? Revocable trusts are revocable by the grantor so long as the grantor is living. So the minute you pass away, that revocable trust turns into a non-revocable trust. But your trustee is able to continue, whoever your successor trustee is able to step in and continue running the trust, and this does not have to go through the probate courts. So if you have that concern of privacy, a trust is very beneficial. But if you also have the concern of paying taxes on like not another dang thing, then maybe trust isn't the best entity for you, right? And trust taxes are higher than LLC taxes. So whenever I do trust for people, I won't do them unless that person has a financial advisor who can be very transparent with their estate, and that person has a tax person that they refer to, because I stay in my own lane. I don't talk numbers with anybody. You wouldn't want me to. So just to have that comprehensive idea, because you don't want to be surprised with additional taxes that you weren't preparing for, right? You just went on LegalZoom and filed a trust, and then you didn't know, oh crap, I'm gotta pay 25% on whatever I just put into this, in addition to my other regular taxes. So you definitely want to make sure you have the trifecta on your team, right?
Okay, so I was ill-advised because I thought people put their property in trust so their kids don't have full control and they can't just sell it when they die. So that's not the protection methodology for a trust. It's just simply a different way to hold an asset.
Yeah, it's a different way to hold the asset, but you're taking your own ownership out of that asset and giving it to this business, right? So like a CEO of a business, the CEO can have its wishes, but whatever it is for the betterment of the business, right? The business can have foundation instructions. So if your foundation instruction is, whoever's the trustee of this home, I never want it to be sold. That could be a good instruction, but the trustee is not dedicated to you so much as it's dedicated to the perseverance of the trust. So if it turns out later on, it is more beneficial for whoever the then beneficiary of the trust to sell or do something else different, then that's something that may happen.
So then it's more tax.
Mhm.
It sounds like more money.
Mhm.
Why don't I just get a LLC? It's just a company. Like, what's the benefit of just the fact that if something happens to me, it's already kind of embedded?
Yeah. So you have some attorneys that definitely believe setting up trust agreements is the right way to go. That's why I said it's a real comprehensive idea of what your estate is like. to really fully evaluate. But then you have some attorneys, one of my mentors included, who believe she doesn't set up trusts for people. She sets up businesses for people, and she transfers assets into businesses where you do have a little bit lower taxes, right? But the laws in place for businesses versus the laws in place for trusts are different. You know, you might not necessarily, if you have a child with a disability and you want them to be taken care of, you might not want to just put it in a business because you maybe want the trust laws to kick in and really apply rather than business laws apply. So it really just, it's just, everyone's different, you know. I would say it is more common to put your assets in some type of trust, but like I said, you do have attorneys who believe that trusts aren't really great for everyone just because of the taxes, and they rather put it in LLCs or something of that sort, you know.
Sometimes I've heard like people say, you're gonna get trust, you should look to have a certain net worth or something like this, a little bit more. This is why you might read in certain places, but it's a little bit more for like not the wealthy, but like you got a little bit more going on.
Yeah. And the same way, I mean, I do business law, so I don't recommend right off the bat everyone to just jump and get an LLC, right? Sometimes it makes a little bit more sense. Right now, you can act as a sole proprietor. Why? Because you don't have any assets really for anybody to go after. If something suits you tomorrow, you can't get what, blood from a turnip? So a LLC may not be the right entity for somebody that's, you know, maybe just started a little t-shirt business and selling in their neighborhood. But then once that t-shirt business starts to grow a little bit and they have a certain amount of revenue that they're bringing in, well, now you have assets. So let's talk about protecting it. So that's when we start, maybe you need an LLC, maybe you need to incorporate, maybe you need, you know, and we kind of delve into that realm there. But like I said, it's not a one-stop shop for everybody. A revocable living trust is very common. Banks know exactly what to do with it. You do get to change it and make, you know, amend it or whatnot while you're living. But so we can look at the requirements, right? As a grantor, you just have to have the intent to create the trust. The trust property must be funded. So it has to have assets in order for it to be. So sometimes I was dealing with someone who thought their parent created a trust, right? They don't went on. I always tease LegalZoom, right? Because it's always that whole, why I gotta pay a lawyer when I could just get on LegalZoom? Okay, when you get what you get, you know? I mean, you know, why I gotta, you know, pay taxes for teachers when I could just get someone off the street corner to read a book to my child? You get what you get, right? So you create this document and it's beautiful. I mean, it has all the legal like words and everything. You feel like you did something, but no one told you had to put assets in it for it to even be real, right? So the trust agreement goes out the window, right? There's nothing, you know, it's just paper that turns into like meaningless.
Right.
So you have to fund your trust, and how you fund it can be various ways. Funding it can mean transferring your house to it, giving ownership, you know, doing a deed to do a transfer that way. It could be opening up a bank account and putting $1,000 in it or whatnot, but funding gives it life. It's like you give birth to the trust. And then you need to designate a trustee to manage the trust and a beneficiary to benefit from the trust. Sometimes one person is all three people. That's fine. But you definitely want to have in your trust plans in place for, you know, what happens when the grantor dies or what happens when the trustee dies. Like how does your trust keep living? And like I said, the downside of the trust, or they are more costly to create if you go to an attorney, you know, because of everything. And I've only touched, like, if you think of the alphabets A through Z, I only went to D. So you think of everything that goes into it and all the planning that's required. Trusts can be more expensive to create, right? And trust does require you to dissolve your ownership because you no longer own those assets, your trust does, right? Just like if you were to transfer assets to the business, you don't own it, the business owns it. So the business, you got to do what's best for the business, at all times, right? That's where we have that fiduciary duty, and once you breach it, all that liability, all those protections that you were banking on while you started it, they start to go out the window.
So even though a trust is more costly, if I'm taking my asset, my property, and I'm putting it into the trust, I no longer, the individual, will have to pay property taxes, only the trust has to pay that as well as the trust taxes, or do I still have to pay property taxes and the trust tax?
Well, the trust is gonna designate who's responsible to do what, right?
Okay.
Trust agreement. But essentially, it would be the trustee of the trust, which could be you, maintaining the property, paying the taxes or whatnot. If you stop, then you could have a fiduciary, you could be caught to have breached your fiduciary duty. Taking it a step further, say if the trust, the beneficiary, you're the first beneficiary, but you also named your children to be successor beneficiaries. So now that you put it in this business and say times got hard and you stop paying the taxes, well, your successor beneficiaries can come say, hold up, this property was supposed to be for us. What you doing? And now they're asking you questions because again, it's not your property anymore. It's the businesses or the company's property, right? So though a lot of times going back to what they said earlier is trusts usually are reserved for people with higher net worth, right? It's not typically for everybody, although everyone can create one. Yes. Yeah.
So scenario.
Mhm.
My great grandfather
Mhm.
has land
Mhm.
and it's in another state. And so it's now that land is in my mother's hands. And so I guess for me, since I'm the one that's interested in, being next in line, but you got these other people
Mhm.
who are not really financially able or haven't volunteered to pay taxes or to take care of the land or whatever. Would it be a good idea to put that in a trust or start moving instead of a will? Because it's air property.
Mhm.
And so, what I've been seeing is that people lose air property
Mhm.
because a family member comes with a lawyer and say, okay, we're gonna sell, or we're gonna do this, that, and the other.
Mhm.
And I don't want that to happen.
Mhm.
But I still want to be protected,
Mhm.
because I know she's not gonna,
Yeah.
be around. But would I have to get a lawyer that is in that state, or could I use someone like yourself because this is where I live.
Mhm.
I don't live in Alabama,
Mhm.
So that's my question.
Yeah. So it wouldn't necessarily, because you're not the one that owns the home right now. It's your mother, right?
Right.
So she would be the one acquiring an attorney in her state to draft up a trust agreement. But the beauty about a trust agreement is that it's recognized all over the United States. Whereas a will, which I had this issue too with a probate case recently. We probated this lady's, her husband's estate, but then she found out he had property in Nevada.
Mhm.
And so they were like, okay, great. You guys probate, you were named executor. Great, you got everything. That don't mean crap here,
Right.
right? The will doesn't mean anything to us.
Right.
So you're gonna have to go through this process again. So I always encourage families, my family included, we are very spread out, military families, so we all live everywhere. And I'm from Virginia, so we have property going from all over the bottom coastal areas. And so nobody wants to fly out to all these different places and try to deal with their courts. So one thing that we can do is we can start putting these properties in trust.
Mhm.
That's one way to do. Another way to do it is, and honestly, my preferred way, especially if you have a designated person that you know is going to take care of the property, deed them.
Mhm.
Go through, file a deed in the county where all the properties are located. That way you don't have to worry about 30 heirs, everyone selling their interest. No, because technically they don't have an interest. That one person is the one that has the interest.
Right.
So, and then also what I recommend, especially dealing with heirship property, when someone dies, immediately go through the court process and get people's names off the property. Because what happens is you got heirship property for 30 years because nobody's done anything. And that's how you have people who nowhere near located in the area or ever dealt with the property, they're able to sell their, oh, okay, I got like a 20% interest, go sell that to an investor.
So you said that when someone passes, immediately remove, you said name from the deed?
Yes.
Like if Tim, Tom, and Jim on the deed, they bought it together 30 years ago.
Mhm.
When Tim died, John, whoever's still living, let's get Tim off.
Yes, yes, get their interest off.
Get him off.
Get him off.
Well, you know, because what happens is if not, which another case I've been dealing with, I got cases for days, but what happens is me and my papa own this house, they died, right? Papa had like 7 kids or whatever.
And they
So
got
now you got
cousins.
all the kids that got an interest, but then Jimbo died, which was one of the kids. But Jimbo, before he died, he had a wife who had 3 kids. So now it's like this tree starts spreading all the way out. And everybody who can be an heir, especially may have some sort of an interest right to it.
Right.
Because what doesn't happen is once someone dies, the law says, okay, they're cut off, and then it's the remaining beneficiaries. That's not the way it works.
Right.
It's all beneficiaries and they're beneficiaries unless you cut them off.
But there's no implication like Jim dies, I will take him off. Like,
If he's-
it's nothing that, you know, there's no.
Well, that's what I'm saying.
There's no compensation of.
Well, that's why I'm saying before Jim died. So once Mima and Papa died, the beneficiaries who say Mima and Papa died, but they had 7 kids, well, all 7 kids Mima and Papa should be off, then it's their kids. And then once one of them dies, the remaining kids do like a super title or whatever,
Oh, I see
to
what
get
you're
the
saying.
interest in just their names.
Right.
Because if you allow Jim Bob's interest to stay on there, it's gonna stay on there, and his kids, if they have kids and they have kids and they have kids, it's gonna they're gonna now, instead of sharing this asset with just the 6 remaining kids, you have 6 remaining kids and 30 other, nieces and nephews and stuff, and then you can't even get 6 kids to agree. Imagine having all those other people.
Yeah, because I'm the nephew is gonna pop up for my 5%.
They come through. They do. They come through.
So when that person dies, take him off and the kids will just do that.
There's so many different ways you can do. So a lot of times they'll waive being on it. They don't have nothing to do with it, especially if you throw that tax word into, okay, you're gonna help us pay taxes. Nah, buddy, you got it.
Yeah.
And they'll go off. Sometimes you file in probate. If nobody wants to contest it, you can try to just get the transfer because they know they have to get an attorney to kind of get in. What some people do is y'all can agree, okay, how about this? We'll band together, we'll pay you $10,000, fall off and let us. So some people, they'll do it, but it's much easier to do it and working with a few people than letting that family tree build up.
Gotcha.
So, but anyway, that's kind of like my spill on that. Because I've seen it, and everybody wants what you got. Even if you don't think I don't got nothing, nobody gonna care. Everyone fighting over something. People fight over crumbs. If somebody thinks they're entitled to something, they want it, right? I think it's just almost human nature, right?
When people die, people change.
Yeah.
We see a lot of certain.
Oh, yeah. Oh, it's in all communities. Probate don't have a face or color. But one thing that affects our community the most is that we have such a distaste for attorneys, distaste for the court process, so we don't go through it. But our society is built up, our legal system is built up where it has to go through the court system. So if you've just been holding it off, that's the difference with other communities. They're not afraid to just go through that process, pay that money then, set up these trust agreements, do things early. And so that way they don't have the same issues with heirship property being taken from them, right? Also traditionally other communities see the value in ownership, land ownership and whatnot. So they also are less likely to want to just sell off interest, right? Because they know we might be oil down here or something. And so people don't want to sell, so. But anyway, that's revocable trust. The downsides, like I said, it could be more costly and it requires you to dissolve ownership interest as the grantor. All right, so talking about deeds. So, I talked about the most common deed that's used in Texas is the transfer on death deed. It is not available in all states. That's why it's good to work with an attorney in that state that you're in to make sure, hey, will this deed work? Or even if you don't work with an attorney, just doing your own research, saying, hey, okay, that transfer deed that crazy lawyer talked about, can I use it in Georgia? You know, you might want to, it helps to do your own research because you can go on LegalZoom and draft one up, but doesn't mean it's going to be recognizable, right? The good thing about a transfer on death deed is you remain the same owner of your property. Nobody else can sell or encumber your property. So say I do a transfer on death deed to my daughter, she can't turn 18 and say, Mama, well, this is the property about to be mine anyway. You better, she can't do that, right? Because it's still, I can sell it and oops, no more transfer on death deed, right? I can still do whatever I want, but it will pass to the other person without probate. So all you would have to do is show your death, show the beneficiaries, not the beneficiaries, but the grantor's death certificate, as well as your license, and then they can transfer the title into your name. Survivorships is great. The difference is with the survivorship, it's non-revocable, right? So typically you see survivorship languages when maybe two brothers buy property together and they say, okay, if one of us passes, you have the right of survivorship. It's just gonna transfer to you. But if them brothers fall out, they can't be like, nah, forget that. I don't want it to pass on to you. I want it to pass on to someone else. Well, you can't do that unless both brothers agree, right? So you kind of get in there together and get out there together for survivorship. But it's another way to transfer an asset without probate. Survivorships are typically common in all states, some form of it. You can give someone a life estate, which basically says, while I'm living, the grantor can give a life estate, say, while I'm living, I am going to be able to just live in this house for life. But the minute I pass, it passes on, right? The difference of a life estate, those are also non-revocable. So I can't say while I'm living, so my oldest daughter's Presley, while I'm living, Presley, I'm gonna live here, but then Presley get on my shoe while out in college and I don't want her to take my property anymore. So I'm gonna say, nah, never mind, forget that. No, Presley would then have to come in and agree to no longer be the beneficiary of the life estate. Good luck with that, right? So yeah.
I have a question about life estates.
Yeah.
You're an attorney, so I know you love hypotheticals, but let's just say hypothetically, I had one of them old grandpas who was a little more misogynistic than he should have been. He put his daughter in a life estate. He passed away. He had a kid. The kid lives in DC. The property is in Texas. And we can't find the kid now. My grandma is getting older. So how does a life estate, because once my grandma passes, it's like the property just gonna go to probate?
Yeah.
What happens?
So here's what happens. So you're saying that your grandfather gave a life estate to one of his children, and one of his children, you guys can't ascertain or know where they are, right? So it also depends on how the life estate is written. Sometimes the life estate can be for a life or abandonment. So if you abandon the property, then the life estate, it's presumed that you predeceased, right? That's another way to look at it, but you would have to look at, what state it's in and,
But essentially, if everybody dies,
Yeah.
everybody,
the life estate ends.
okay, but the person that owns it, the beneficiary,
Then it
can't be
reverts back
found.
to the grantor. Oh, the beneficiary.
Yes.
Yeah,
Let me fix
that's what
my
I'm saying.
example.
The beneficiary can't be ascertained, can't be found, right?
Can be found.
So the life estate would possibly could be for life or up until abandonment. So if somebody abandons the property.
Hey. So then it just sits and
No, it doesn't just sit.
does the state try to get it?
What I would try to do is I would just go through probate. Say, what it would be is it would be falling intestacy, right? So intestacy proceedings are a little bit different than just probating a will. Intestacy, what the court's going to do is they're going to hire an attorney ad litem to come in and do an investigation of the heirs. They're gonna try to find that individual. If they can't find that individual, then the court's gonna make a decision on who would be the heirs of that property.
Okay.
So, yeah, yes.
So my grandparents, they had 5 kids,
Mhm.
right? And I've seen their wills. And sometimes a kid might have done something they didn't like. They would always leave them $1. Or they would put something in the will that said, if so-and-so is doing this, that, or the other, then they don't get something, or they don't get a portion, but they get $1. Is that a Texas thing where you have to leave something to?
No, I mean, you don't have to leave anything to anybody, but when you think of the world of probate and how everybody wants something, right? It's called, what they're essentially doing is disinheriting, right? But, and you know, and every situation is unique. So again, I have that disclaimer, talk to your attorney. But I have made recommendations for people to leave somebody, like I just did one and she felt anime, he doesn't get anything. We agreed to $2, right? But it's because one, he's identified as a child, right? Because you don't want it to come back saying, oh, well, this was just a forgotten child. So we're gonna disregard this will, right? We want to make sure the will is as valid as possible.
Thought about it.
Yeah. Yeah, we want to know that this person was identified, considered, the testator was in their right state of mind. And then we also sometimes use the language, all other inheritance he already received, right? Because I done bailed this mofo out so many times. And so we use that language that he's already received his inheritance while I was living. So at this point, I'm gonna leave a little bit, you know? So it's just, again, it's getting involved with your, you know, with your family. So estate planning attorneys, you know, it's good to have one that, you know, is gonna take interest. And those are things that LegalZoom ain't gonna give you. And again, that's the last time I say LegalZoom, because do what y'all want. But it's knowing the family, knowing what's going on. You know, sometimes you may have somebody with, you know, unfortunately with an addiction. And it may not be in their best interest to leave something because they don't, you know, whatever happens, or you have somebody that, you know, with a disability and they depend on Medicaid. So you don't want to just turn around and leave them $100,000 because guess what? Their benefits are cut off.
Right.
You know, and they don't know how to manage something like that. You know, so that's something I have, you know, 2 clients right now with children with autism, and they want to provide for them, but we're trying to navigate the best way to do it while they're still getting benefits, you know? So there's a lot to consider when you think of the complexity of your families on what's going to be best for you.
So if you do that LegalZoom thing, you have the document, you have people sign it, you have it notarized, but you stop. You don't take it to a lawyer. You don't go through the court. What can happen when that person passes away?
So, I mean, think about this. What is your purpose of creating a document in the first place? It's creating a plan so that your wishes are essentially what's going to happen once you pass, right? So if your wishes, your actual wishes aren't memorialized how you really want them, then remember when I said earlier that the courts, if as long as it's valid and it has those main requirements, the court's just gonna say, okay, that's what you wanted. So if something where, you know, if something happens and it's not what you wanted, well, that's what's on this paper.
Right.
And that's kind of like, well, my husband wouldn't have wanted that. My husband wouldn't have wanted, but that's what he had on this paper. Right? My husband didn't even talk to that kid anymore. And blah, 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 blah. And they, you know, he almost killed him, blah, 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 blah. Yeah, but that's what's on this paper. So
How do you, what's the difference between, like, say you have a situation where you're a caretaker and you have power of attorney. Does the person that you're taking care of still need a will if they're already labeled incompetent?
okay, well, they can't write a will. So one of the biggest, the number one thing that when we talked about earlier is for a will is you have to have, did I put it on here? Okay, so it's not on there, but you have to have legal capacity to enter into a will. One, you have to be 18 or older unless you're in the military. And then another thing is you have to be legally competent to write a will. So even though someone has a power of attorney over you, they can't necessarily just write a will for you, right? You're just gonna pass. What they can do is that they can use their power of attorney to maybe transfer assets, designate beneficiaries. They can do things like that, but they can't necessarily write a will for you.
But I thought that was only while you were living.
While you're living, well, a power of attorney dies when you die.
Right.
Nobody can have a power of attorney over you after that. So
So what happens to your asset?
it falls in testacy. And that's where I was saying
Dang.
before, it has to go through probate, the attorney, and that's a little bit more expensive process, but because the court hires their own attorney to talk to the family, investigate what happened, who's out, who all the potential heirs could be. And the court kind of determines the type of administration that's gonna happen with that type of case. So it would still go through the court, it's just not as quick or as easy, sometimes as a probate of a will proceeding. So that's
So
typically
this is
what
why you
happens in
say
those situations.
every 4 years, review it, because if not, and some tragic happens to you, it's too late.
Yeah, so when you think of estate planning, it's not just a will. It's like what I tell people is like, oh, I don't have enough assets. You're already estate planning if you put a beneficiary in your checking account. That's already part of it. And you know, beneficiary doesn't, if you do life insurance, you're already estate planning, right? Estate planning is just looking at all of it holistically and making sure that you have a plan in place. Because my goal is not to, even though I'm a probate attorney and probate is really what pays my bills, my goal is not to have everyone go through probate, because once your beneficiary realizes that, oh, I got to hire an attorney and pay $7,000 to go through the court, you know, that's kind of like, I don't want to do that. But you could have avoided that by putting beneficiaries, putting an alternate beneficiary, creating deeds, and you know, doing all of this other things to try to pass your assets outside of court.
So if you designate a deed, then you don't necessarily need a will for your estate. If it's just like a house or like.
Always recommend having a will as your just in case, because something could happen to you before you've updated that deed if needed, or something can happen to you with, you know, whenever. And, you know, because sometimes deeds and all that stuff takes time. So having a will as a fallback plan is beneficial. But like I explained earlier to them, a will won't trump the other things that you have done. What the court will do is just scratch out that provision. So if I willed my house to my oldest child, but I deeded it to my husband, then the court's just gonna cross out that will, that house deed, right? Because, oh, it's already contracted somewhere else, we're not gonna apply that provision. But if me and my husband died together and I deeded him, well, the deed is no longer active, but at least my will said where the house is gonna go just in case, right? So that's that. Another deed that's pretty common is called a ladybird deed. You usually see this with people that have Medicare, Medicaid benefits. A ladybird deed is only available in Florida, Michigan, and Texas, and really allows the grantor to maintain a life estate while transferring the title to a beneficiary. And it enhances eligibility for Medicaid, right? So Medicaid doesn't necessarily look at your property as one of your assets. You know, it's pretty much become like a non-exempt asset, right? But the beauty of a ladybird deed, that's why it's called an enhanced life estate rather than a life estate, is that, remember, the life estate is non-revocable, but a ladybird deed is revocable. Okay, so, and then the last one that people use is rights for entirety. This is available. I'm pretty sure it's available in all states, but I'm not sure. But that's something for married couples, right? The common misconception is, oh, I'm married, my spouse is just gonna get the property. No, interest does not just transfer like that, right? So you wanna have some type of rights of entirety or something in place. So if you want your assets to pass to your spouse rather than just, you know, making the assumption that your interest is gonna just automatically transfer. And this is another way to transfer it to your spouse without going to probate.
Common transfer deeds, like, in a perfect world, like, is this something we should be encouraging our clients to
Of
do?
course.
Like, closing, right after, like kind of
After closing,
right after?
you know, yeah, because sometimes mortgage companies don't want, oh, who's that other person? Okay, now bring their licenses and do all this stuff. But sometimes after closing, it's important. Now it's not, you're still gonna be responsible for the mortgage. Don't be like, I bought this property, ooh, child is transferred. You take care of it. No, 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 because the mortgage that's a contract. So if you lose the house, they lose the house.
So
but-
So we almost should, like, they closing, like, and I'm thinking from a, I'm sorry. from a business
No,
perspective,
go
like,
Add a guideline,
Yeah.
add a guideline.
And, you know, Bobby closes, okay, Bobby, now why don't you, call ABC Life Insurance, call just to start getting this kind of stuff.
Set up.
Right.
Yeah, it's good. I mean, but also it's knowing your client, right? Some people may not even, they may not see that home as a forever home or something they want to build a legacy off of it. They may just want it a good couple of years because I don't want to pay rent nowhere. I want a good couple of years and I'm gonna sell it and transfer it on, right? So it may not be beneficial for them to do some type of deed work. They might just keep the original deed and going through probate, fine, no issue. What I would recommend everyone to have, in fact, Houston Community Land Trust is now requiring everyone to go through it, is to have a will. So have something rather than nothing, right? Because we don't know tomorrow. So that's that. And then for Justin, I added that no deeds must be filed prior to the grantor's death and with the clerk of the county where the property is located. So you can't file it in Harris County, but the property's in Montgomery County. It's not gonna work. You have to file it in the county where the property is located for it to be valid, and you have to do it before the grantor dies. So I get a mad rush of calls sometimes from family members whose parents are on their deathbed. And they are like so concerned that mom and dad's about to die any minute now. I need a deed. I need the deed. I mean, and it happens, so I'll make a hospital run, and, get the notary and stuff like that, because I get it. We want to protect property. You may not have thousands of dollars to kind of go through probate or something. So, it's easier to pay $18. Yeah, it's to file it, draw it up, file it. You can, and I'm not gonna lie, you can find sample deeds online. You just want to make sure you research and the requirements for the deed, because if you don't have those right property descriptions and you just went on the appraisal district and that's the property description, a lot of times those are wrong, but you put that on there, then guess what? You don't have the property. That deed didn't transfer correctly. So you do want to make sure, even if it's a couple hundred, you're paying an attorney to do it. You want to make sure that person was able to do the research and know that what you're transferring is, or what you're filing with the county clerk is exactly what you intended to file with the county clerk. Yes.
So if scenario,
Y'all love scenarios. Ooh, taking me back to law school.
you have a parent
Mhm.
and that parent still has a mortgage on his house, although it's not much, but this parent really needs to go in a nursing home. Would a ladybird, or maybe not a right, but would a ladybird, let's say he puts it in my name, but then can be eligible for Medicaid to go into a nursing home, even though he don't like nursing homes?
So when you think of life estates, you're thinking of life estates. Ladybird deeds were designed to keep people from kicking their parents out their house,
Okay.
right? So your idea of having a ladybird deed is your parent still wants to stay there. They don't want to necessarily go to a nursing home. They want to stay there because there is that issue of abandonment. Life estates are for life or for abandonment.
Right.
So if you leave the place and go stay somewhere else, then technically your life estate ends. And that's kind of a scary place to be in, because now someone else, your child or someone, can just come and now they live there. And if you ever want to come back, right? So it creates that weirdness that goes on. What I would do, and it's not up there, maybe just transfer. If you want to do if you want to move into a nursing home and it's permanent until the person passes away, then just deed the property over. It's not, I don't have just deed, it's just a regular deed,
Mhm.
but just deed the property over. Just keep in mind the tax, we love taxes, right?
Taxes,
The
taxes.
taxes, ramifications that happen when you deed, because it's what's considered a gift deed. And
Right.
so
Yeah, so they
you
should
have to,
responsible for the property tax.
not just property tax, just tax. You just received a $250,000 gift.
Oh,
So you need to claim that $250,000 gift on your taxes.
okay.
So that's why some people don't like that necessarily, because it's like, oh crap, I won't anticipate it. I was waiting for that refund check to hit.
Right.
And so it's just, again, it's just one of those things that if you have questions about doing it, definitely talk to a professional to kind of like figure out, okay, is this the best decision for our family? Always ask, well, what are the ramifications, right? And then that way you can weigh it and make an informed decision.
Mhm.
So
Thank
that's, yeah, of course. And lastly, we talked probate. So it's good to know what is probate. So probate is the judicial process of transferring an asset of a deceased person, either by will or intestacy. Intestacy is not having a will. Common types of probate proceedings are you have independent administration, small estate administration, what's called a monument of title, dependent administration. These are in Texas. Different states may have different proceedings. That Cajun law, Louisiana, I don't even know what they do, but I just know everything is different in Louisiana. Same thing for California. Everything's a little bit different out there. So you definitely want to make sure you work with someone to know which proceeding is right for you. And some of them are cheaper than others. In Texas, all proceedings will require the public posting of your estate. So, when you file those applications with the court, I can't put on the top private confidential. They're gonna say, well, okay, and still put it on their public page. And you have people that just watch what's being probated today, Some proceedings will require the appointment of an attorney to assist with probating your estate at the expense of your estate or your beneficiaries. So that's that attorney ad litem. I said, like, if you have something falling in intestacy, the court's going to hire an attorney to kind of come in, but the court's going to pass that cost off to you. So whatever their costs could be, they could be a couple of $1,000s. You're going to have to pay that as the beneficiary, or you're going to have to pay it out of the estate proceeds. So just keep that in mind about probate. It's public and it costs.
That's the takeaway.
It's public and it costs, yeah. So that's why I said estate planning, either when you die, something's gonna happen. Everything costs, right? So estate planning is you paying the cost up front to make the transition easier. Or you cannot pay it up front and then your beneficiaries pay it after. So it's just, it's however you want to do it. So how does this apply to home buying? Your asset. The minute you purchase or gain interest in a home, that home becomes your asset and part of your estate. I know we talk, a home's a liability because I got a mortgage or whatever. Yeah, but when it comes to transferring your estate, it doesn't care about your liability. It's just the minute something's in your name, you have an interest in it, it's part of your estate. So when you pass, your interest needs to transfer to someone, right? Your liability. Should you ever be found liable in a court proceeding, creditors can place a lien on your property. So that is something to keep in mind. That's where trust and everything come into place, or putting it in a business entity come into place. Because sometimes people say, I have this big, beautiful mansion on this airship property I've had forever. I don't want somebody to just come in and just put a lien on it, right? So I'm just gonna go ahead and put this property in a trust and put what's called like a spendthrift provision in there that just kind of stops people from just coming in and taking it. But also write down that it don't work against child support. I had this conversation with someone earlier where they wanted to, just put my stuff in a trust. My baby mama can't get it. Okay. Yeah, that's not the way that works. So there are certain creditors that can still pierce it and come get your stuff. So, but anyway, a trust can stop most creditors for coming and placing a lien on the property. It's not going to prevent child support and it's not going to prevent taxes. So don't think I'm 50,000 behind in taxes. I'm just put this house on a trust and the county can't close on my house. Yes, it can and it will. So, and lastly, your responsibility. As a homeowner, you are the one responsible for making sure your assets are legally protected. So for me, those are why it's important to think asset protection and think estate planning while you're buying a home. So things you can do when buying a home to help with asset protection. Step one, update your will. Include your home purchase in your will. Designate an executor who can manage your home and distribute the asset to beneficiaries once you pass. 2, consider deeding your home to a beneficiary in order to avoid the added expense of probate. Notice I put will first because you should always have a will, and then take the initiative to do the other steps. And step 3, consider putting your home under a trust. Trusts are not beneficial for everyone, so always talk to an attorney and tax professional first. All right, I have a hypo. I'll read it because it's probably kind of hard to see from here, but we're going to talk about Harry and Meghan. Harry and Meghan, they're getting married. Just before their marriage, Harry decides to surprise Meghan with keys to the new home that he purchased. All right, can y'all still see? Well, I don't know, something's going to happen. All right, I think the internet's starting to get wonky. All right, so Harry and Meghan are getting married. Just before their marriage, Harry decides to surprise Meghan with keys to the new home that he purchased for them to raise their family. Meghan thought the house was perfect as it had just the right amount of space for their twin 5-year-old boys while having an extra bedroom for Harry's 10-year-old daughter to stay whenever she was over. After 10 years in their dream home, Harry was tragically killed in a car accident and he did not leave behind a will or trust. When Harry's bank learns of his death, they immediately freeze his accounts, causing the mortgage to go unpaid. Meghan, who at the time was a stay-at-home mom to their newborn, hires a lawyer to help her probate her husband's estate so she can catch up on their mortgage. However, she is shocked to discover that Harry's estranged adult daughter receives a 25% interest in her home. Meanwhile, Meghan is entitled to a 1/3 life estate for the house, which means she can live in it, but cannot get debt against it or sell it without her husband's first child's consent. Meghan is now stuck in a house she can't afford, with a partner she can't stand to deal with. This is not what Harry would have wanted at all. So what do y'all think are some things Harry and Meghan should have done differently to protect the asset?
Well, if Harry would have had a life insurance policy with a rider for his spouse, then even though the older daughter would have had the 20% claim through the life insurance policy, the wife would have been covered.
The wife would have been able to have money to pay the mortgage. Yeah,
She still don't have. full
but she
control
still
of the
doesn't have
property.
full interest of the property.
So then,
Should have did the one with the married couple.
Yes, survivorship with the right of entirety.
Yeah.
Yeah, they could have deeded entirety deed. He could have done a will, which transferred his interest to his wife. He could have put his house in a trust for the benefit of his wife, or, as an alternate beneficiary. There are a lot of things that he could do. And this case scenario is a common intestacy problem, right? You have husband and wife, they're married. Husband had a house outside of marriage, right? I'm sorry, not a house outside.
Man, sure you do 'em like that.
outside.
All that, we know what you're saying.
Yeah,
Just
so
with-
he had a child outside of their marriage. So in intestacy, if husband and wife were married and all their children were from them together, then wife has the way of the courts just transferring all the assets just to her. But the courts are gonna feel like, okay, you didn't write a will, so in our mind, you would want to protect all your children. So if you really wanted it to go just to your wife, then you would have did that. But since you didn't do that, what we're gonna do is give her a life estate. She can live there. 1/3 life estate. That 1/3 is for a tax code. You can, using math, you can calculate the value of your life estate, right? So you're gonna get that 1/3 interest. We're gonna then divide your home, your husband's interest amongst your remaining children. Okay, so essentially where that life estate, where we talked about earlier, you can't do anything major to the property, including selling it, without your alternate beneficiaries agreeing to it. So, you know, she want to sell it, because she's like, I can't afford it, and the child, with the 25% interest is saying, no, figure it out, then she's stuck. And now you're paying property attorneys, like it's all these other people that try to help you get out the house, or you're risking not being able to afford it and getting it foreclosed or getting the lien put on it. And it's just a lot of issues that happen. So you definitely, especially families that are in mixed families, you want to have some type of planning in place. Another thing that is important, you think, oh, well, they bought the house together, community property. No, he bought it before they got married. So it's technically his separate property. So this happens a lot because you get excited. I wouldn't get excited that my husband bought me while we were dating, he bought me a house. I'd be excited when he put my name on the deed. Right? So that's where I try to tell you, get excited for the right thing, because I have seen it where man had this house. I've had this client before, had the house, they got married, they've been living in the house, and then the minute he died, his adult children came in and changed the locks. Said, you gotta go. This is my daddy's house. And it happens. I mean, this lady had to change the lock back 4 times because they kept coming. Whenever she went to work, they changed the locks. So it's just, but they have part ownership of this home. That was a separate property. It didn't just pass to her. So she maybe can do a claim for contribution because, oh, well, it was our community funds that were help paying the mortgage. Yeah, okay. But you can get a payout that way, but that doesn't give you an ownership interest in this home. So that's what's kind of going on in play here. There's a lot of different things, but when I was writing this, I was like, and let's do this and let's do this. So I put like 8 clients in one in this one.
So the insurance would have to pay the more, get caught up on her payment. But he still would have needed to have one of those spouse, I don't know the name.
Yeah, you would need to transfer ownership. You can't do that through life insurance.
Yeah.
Yeah. So that's kind of that's what was going on there. This is my information. It has a QR code. I do have cards in case you guys, if you have questions earlier or something else, comes up or you want more information. Here are some cards, and here are some business cards. But yeah, so estate planning is something we all need to take seriously, and we all need to do now. So if you don't take it away, if you don't take anything else away, I want you to take away, I have an asset, because that's a common misconception. I don't have any assets. You do have assets, right? Even if it's just the clothes on your back, you have an asset. And you need to start planning. So
And you make house visits?
Yeah, I make house visits. Yeah. So at this time, does anyone have any more questions for me? Because that's pretty much all I have.
Oh,
Schedule appointment.